Well, it depends where you're starting from. If you were asking me where I would situate myself in the American landscape, I'd be a raving liberal. So, but it's nice that I live in Canada. Although I've made a number of very liberal leaning decisions in my life, I'm still considered a centrist. I think that's a wonderful statement about this country.
Beverley McLachlin is an extraordinarily accomplished Canadian. She was raised in a rural farming family in Alberta in the 1950s in a home without running water and electricity. She grew up and studied law at a time when women were not at all well represented in the field. She was a law professor at the University of British Columbia. She served on BC's Supreme Court and Court of Appeal, and she became the first female Chief Justice of the Supreme Court of BC in 1988. That achievement is already impressive, but then she rose to the highest seat on the highest court in the country. In 1989, at the age of 45, Prime Minister Brian Mulroney appointed her to the Supreme Court of Canada. 11 years later, Prime Minister Jean Chrétien appointed her the country's 17th Chief Justice and the first female Chief Justice of a Commonwealth nation's Supreme Court. When Beverley retired, yes. Yes. When Beverley retired in December 2017, she was the longest-serving Chief Justice of the Supreme Court of Canada. Now, the fact that these latter two appointments came from a conservative leader and a liberal one is not at all surprising. As a jurist, Beverley McLachlin was known as an independent thinker, someone who was respected and admired across the political spectrum, and was at times also criticized across the political spectrum. In the Globe and Mail, Justice reporter Sean Fine wrote that Beverley McLachlin put her stamp on some of the most pressing legal and social questions of 21st century Canada. She helped shape Canadians' fundamental rights as much as any judge in our country's history. From the legalization of assisted dying, to a huge expansion of Indigenous rights, to a rebalancing of how police and the legal system treat people accused of crimes. If all that were not enough, Beverley has, in her semi-retirement, embarked on a new career as a writer. She's the author of a really terrific legal thriller called Full Disclosure, which was published by Simon & Schuster Canada earlier this year. Please welcome once again, Beverley McLachlin. Thank you. That was a lot.
Yeah. I thought, wow.
You're very impressive.
I didn't do all that.
I want to start with an issue that I know is a significant one for you, and one that you have spoken out about. And you know, typically judges are somewhat of a cipher. We don't hear from them. They avoid, weighing in on public issues. In 2011, you gave a speech that caused a stir. At a colloquium, you spoke about access to justice, saying, "Access to justice is an issue dear to my heart. It is a fundamental right, not an accessory." And then you went on to ask, do we have adequate access to justice? It seems to me the answer is no. We have a wonderful justice for corporations and for the wealthy, but the middle class and the poor may not be able to access our justice system. So what were the barriers you were witnessing at the time when it came to access to justice?
Well, a lot of people would sadly say, or I would hear through friends and family, that people were just unable to resolve their ordinary disputes. Perhaps they're separating. A husband and a wife are separating, and they say, well, we need some legal help to sort things out, and so one of them goes to a lawyer, and the lawyer says, well, I'll need $10,000 before I can help you. And at that point, they didn't know what to do. There was no information out there. There was nobody to say, well, you can go to this and this place, and there will be a pro bono lawyer or a law clinic or a student. At least you can find out something about how to proceed. And not everybody, is a gifted legal researchers. So people face complex legal problems, and there was nowhere to turn. And I started to think about that, and I thought, this is not right, because as you mentioned, I believe that justice is there for the people. It's one of the most basic functions of the state, to provide a justice system that will try to heal the wounds that wrongs make, that will try to help people who are in dispute settle the dispute and move on in their lives. I was seeing people who were totally consumed by their legal problem, to the point where they were becoming unproductive, they couldn't think about anything else, they couldn't move on. As a trial judge, I saw people who were often driven to hatred and anger because of their domestic situation and this feeling that there was nowhere to turn. So I thought we as a Canadian society can do better. A long time ago, Pierre Elliott Trudeau talked about the just society. And of course that means a lot of things. It means healthcare and education and all of those other good things. But it must mean at some level the ability to get justice. So when I gave that speech in 2011, I didn't really expect that much response, but the response was enormous. Many, many people. I could see that I had touched on something that was really, really important and was not being adequately dealt with in our society.
And if you were empowered to make sweeping reforms, what would you, I mean...
Give me a royal commission. I don't
give
know.
you a royal commission.
But you know,
maybe something faster than that.
Yeah.
If you were just sort of given a magic wand and could build things into the system that would make it that would address these concerns, what are some solutions to this?
Well, in the last 7 or 8 years, there's been a lot of work done, and what we've realized, because there was a lot of response to what I said, there were new groups set up, like the Family and Civil Justice Organization. Attorney generals came on across the country. The Justice Department in Ottawa is very involved in this. And what we've discovered is that it is a complex problem. There are all sorts of court cases. There are all sorts of justice problems, many of which don't even get to court and probably shouldn't get to court. What we have is a complex problem, and there are no silver bullets, but there are a lot of things that are very effective that we can do, concrete things. And we can look at our court procedures and we can try to streamline them. We can provide help, whether it be through clinics associated with law schools or benevolent groups. Pro bono is a terrific program. That's been in the news lately because we had great pro bono clinics in Ottawa and Toronto, which weren't there in 2011. These are responses to the problem, helping many, many people who could not find a lawyer and were going to court, would otherwise go to court themselves, which is another problem or issue. But we saw these people going and getting help. And law firms were buying in. They were saying, okay, it's a good thing for some of our younger lawyers to go and spend a day every week or two advising people. And if they get a case, go into court and act for nothing for that. And law firms were finding it was the right thing to do, but it was also giving these young lawyers experience, because one thing young lawyers often tell me is that, you know, they're junioring and they're seldom getting on their feet in court, so they can't get that experience. So, and I believe that the pro bono clinics and things like that save the public money, because it costs a lot of money to run courthouses. You have to pay judges, clerks, court stenographers, you have to provide the space and all the infrastructure. And when people don't have legal help, the cases they come alone, and I don't blame them for that. Our justice system is open. You don't get turned away because you don't have a lawyer. But the cases take twice as long. We have an adversary system. The judge is supposed to be impartial. The judge, just to make the case move along, may have to give advice. That may kind of skew the perception. And it costs a lot more money in the end for less satisfactory results. So we want to work on all of these initiatives. I could go on. I'll just mention one more that I thought was imaginative, and that was, we're in a library. This is an initiative that someone came up with to give librarians information, networking information. And it turns out that a lot of people who don't know where else to go will go to a library. And they'll say to the librarian, where should I go? And now, these librarians aren't giving legal advice, of course, they're not lawyers, but they might be able to direct the people to someone who can help if they have the information. So there's lots of things like that, court programs to provide information. I've gone on too long, but it's a big subject.
Yeah. You joined the Supreme Court not too long into the early years of interpreting the Charter of Rights and Freedoms. And it was a time when there was a tension and questions about what were the roles of Parliament, the executive, the judiciary, and these were kind of, taking place at that time. Can you talk a bit about how you and your fellow justices debated this? I mean, I know you can't spill all the secrets, but I'm curious. I mean, really, you were on the court at a time when so many of the very important decisions that were actually, creating law in Canada were happening. And I'm wondering how you dealt with that responsibility and dealt with that tension between what is overstepping, what is appropriate, how do we know?
With a great deal of reflection and sometimes soul-searing questioning. Just by way of background, most people here would probably know this, but democracy isn't just about Parliament and the legislature. Democracy there's three branches of governance, political scientists will tell you, and there's the legislative branch, the executive branch, which is Prime Minister, Cabinet, and all those agencies that they set up to look after us, and then there's the judicial branch. And that is the way our tradition and our Constitution distributes powers. So the question a lot of people were asking after the Charter came into force was, is this going to change the power of the judiciary? Are the judges going to become more powerful at the expense of the legislature and at the expense of the executive? We had what was, on the English model, a parliamentary democracy, where Parliament, in theory, could do anything, although the common law was coming along and saying, there's some rights here, and you can't do whatever you want. But none of it was written down. Then in 1982, we adopt a Charter of Rights, we repatriate our Constitution, and we become a constitutional democracy. That means that even Parliament is subject to the Constitution and the executive. So it was a fundamental change in how we organize our democracy. And there had been people in the debates leading up to the Charter who quite rightly said quite rightly there was a debate about it. And some people said, no, that's why they put in Section 33, the notwithstanding clause. But basically there are these three branches of government, and the question you raise goes to the balance between them. In the early years of the Charter, before I got on the court, the Supreme Court set out the basic principles. There'd be a broad and generous interpretation of rights, and then under Section 1, there would be, we would define limits on those rights, because sometimes individual rights conflict with other social goals. This turned out to be a very generous pro-rights approach, and there were many people who were dismayed and thought that recognizing things like same-sex marriage, transgender rights, more rights for women, equality for minority groups, many people vocally or perhaps silently found this uncomfortable. And so there was a lot of criticism that the court was activist, whatever that word means, and that the court was going too far in making laws, whatever that means, because judges in the common law system have always made laws to some extent. That's how the law grows and develops to meet the changes of society. So, but I always thought my job is to call it the way I see it, after a lot of thought and after listening to all my colleagues. And Bertha Wilson, when I first came on the court, she was the first woman on the Supreme Court, a really great lady. And she said to me something very important. She said, the job of justice on this court is not just to vote the way he or she sees the question. We are not just 9 people, each of us casting a vote. Our job is to vote our conscience, and according to the law as we see it, after we have listened to all our colleagues and had that discussion and debate. So this is what happened. We had a lot of discussion and debate, and even so there were a lot of dissenting judgments in those first years, and a lot of split decisions. And looking back, it was tremendously hard work for those judges before I came on the court, because they were asked to take a very general document and give meaning to it. And I think they did a pretty good job, pretty good start. So I got used to, I followed Bertha's advice. I would always listen to my colleagues. I would think about what they said. And if at the end of the day, after having taken all that on, I still was of a certain view, then I would vote that. I would say that in my judgment. And one thing that happens is also that you develop a very thick skin. There's a reason judges have judicial independence, because it allows them to sometimes take decisions that others might say would be courageous, and know that unlike a politician who's going to take a lot of flack and might get voted out, they can take the long term. So when you're looking at a controversial thing like gay rights or something, you sometimes have to take the long term. And I think that's what's so good about the relationship we've developed between courts and judges, and the courts and the legislative and executive branches. Courts can often look at problems in society and take them on before the legislatures can. And in that way, the issues, gay rights is a good example, get up there. There are a number of decisions, and they get talked about. And finally, the Parliament can take it on. It was Parliament that voted for same-sex marriage in the final analysis. But the debate that went on had its beginnings in legal, because no politician was going to say maybe 1 or 2, but not many.
And it's interesting because I think the very thing that people, when people talk about, quote, activist judges, they'll say, well, they're appointed, they're not elected, they don't necessarily represent the people. But it seems to me that the fact that judges don't have to worry about being reelected, that they're not as married to thinking, am I going to anger somebody just before the next election, that in a way it might give judges more leeway to anticipate, to stay on top of changing social norms and even anticipate social norms in a way that perhaps the Parliament or the executive can't. Is that fair to say?
Well, that's exactly it. The reason judges have independence is not to give them a perk. Judges are independent because they have to be impartial. And not only do they have to be impartial, but there has to be the appearance of impartiality, or people would think they're not getting justice, and the justice system would fall into disrepute. So judges sometimes have to make difficult, courageous decisions, not just in the constitutional area, in many areas. They have 2 parties before them, for example, and they have looked at the law, and they've listened to the submissions, and they think, I have my conscience and the law is telling me I have to make this decision. But that could be a decision that really angers one party, or it could be a decision that is ahead of the general norms. And the judge has to be in a position to be able to make that decision. There are, in the United States, many judges who are elected. I've always just been really happy that I was not elected, that I didn't have to get out there and buy votes or promise that I would be really tough on those people or those people. I just was appointed, which is so nice, and then told I had this wonderful job until I was 75, and just do a good job of it, and I tried to.
Now, as I mentioned in the introduction, you very much are known for being independent, and for when you were to look at sort of your record, it is there's not a traditional political ideology in it. I think there are some justices where you can say this is definitely a more left-leaning justice and definitely a more right-leaning justice. So if you weren't if you weren't looking to a political ideology to help guide your decisions, and you talked about sort of listening to your colleagues, would you say though there is a theme, or there is, if we were to look at your record, would you say that there is something that would define how you decided? Do you feel that?
Yeah. Well, it depends where you're starting from. If you were asking me where I would situate myself in the American landscape, I'd be a raving liberal. So, but it's nice that I live in Canada. Although I've made a number of very liberal leaning decisions in my life, I'm still considered a centrist. I think that's a wonderful statement about this country. What is the theme? Well, maybe none, because I've always tried to vote on a case-by-case basis, and I never believed a judge should have an agenda. When I came in as a Supreme Court judge, I didn't have an agenda. I think an agenda that is a very egotistical thing for a judge to have. You're not put there to carry out what you think. You're put there to judge between people and sometimes the state and institutions, and to make the very best decision you can make. And a judge, your agenda might be way behind the times. It might be wrong, and it might foreclose you from listening, which is one of the most important things you can do as a judge. Probably anything you do, but the big key to judging, I think, is listening, and really listening. Listening in the sense of, no, I took down a note. No, listening in the sense of really trying to understand where that person's coming from, where that issue's coming from. What is the real problem here? And what is your grievance? And then listening to the lawyers who, in very learned terms, will tell you where the law has been and where it might be going and what the pitfalls of this or that decision might be. And so after all that listening, you then have to make your decision. And I feel if you had an agenda, you wouldn't be listening. You'd be saying, well, I want to tick this one off, so I'm advancing my particular agenda. So that was just my philosophy as a judge.
Do you think from those days, sort of in the late 80s when you joined the court to now, do you think now Canada has the balance right when it comes to the distribution, the roles of the judiciary, the executive, and the parliament? I
actually think we do. And I always have said that the primary role is for the elected people, the legislatures. And I'm a big believer that we can legislate rights, be they negative rights, freedoms to substantive rights, things like, health care and education and these things. And as I said, we're a constitutional democracy. Every branch has to try to put rights forward. And so legislatures and parliament are very, very important. And because they're elected, the courts give them some deference. And we are always, especially on social and political issues, social issues, complex issues, the courts are going to often be deferential to the legislatures or parliaments' choice, because they're there, they're elected, that's their job, to work out these complex schemes that will further rights, both negative and positive. And so it's not, I think we have a stance where courts do step in sometimes and say, yes, this law violates the Charter. It may be not entirely, but there may be a small aspect of it that's wrong, and then rule against that. But it's always done after careful consideration of all the arguments and with a view of respect. And that's the key thing is respect. I think Parliament and legislatures have to respect the courts, and they do. They enforce their decisions even when they don't like them. And it's really important for our democracy that that be the case. And it's important also that the judicial branch respect the executive and the legislative. And I think we've worked this out pretty well in Canada. Professor Hogg and Hebert wrote an article some time ago, but it encapsulated this kind of symbiotic relationship. And they use the metaphor of dialogue, not real dialogue. We don't sit down and jaw with the Prime Minister, but the metaphor of dialogue. What does that mean? That means that a citizen comes to the courts and says, this law treats me, it discriminates against me because of my minority status or my religion. The court says, yes, you've got a point on the charter, and that person wins. And the law is perhaps narrowed or struck down. But that's not the end of the story. The headlines say, oh, court strikes down law, and people say the world is ending, democracy's over. But it's not the end of the story, and this was Hogg's point. Parliament can take this up again, and does. And I could give you any number of examples where there's been initial dismay at a court decision, and then 2 years later, Parliament has enacted virtually the same legislation, but without the offensive bits, and everybody is in a better situation. We have a better legal system and a better set of laws because of that. Mm-hmm. And that's what he means by dialogue, responding to each other. Mm-hmm. And I think it's worked out quite well. It's a very long way of answering your question. I'm sorry.
Not at all. You mentioned America, so I'm just going to ask you this question. You don't need to answer it. But I'm so curious to know what you made of the nomination process for U.S. Supreme Court Justice Brett Kavanaugh. Because I feel like it would have been really fun to have been at a dinner party with you and some friends around that process. Because I feel like you would have such insight to what it means to be appointed to a Supreme Court and watching what transpired. What did you make of that?
Well, the process is I was a little sad. I understand that Senate review is part of the Constitution, and it wasn't a bad thing, and it isn't really, to have a second look at whoever the president is proposing for a judge. We have developed kind of a committee system. But the problem is that in the United States in the last 4 or 5 decades, it's become extremely politicized. They didn't even used to have hearings a lot of time. The Senate would look at the choice in the paper and say the person's obviously a qualified jurist, end of story. But now it's become a really big political drama, and what's changed is the culture for many people. Many people now seem to believe that there is a Trump judge or an Obama judge, and that that the Supreme Court of the United States is just a mirrored reflection of the political divisions that we see in Congress and the presidency. And that's, to me, not the role of courts. As a judge, I've already said this, I'm there to vote for what I think the law requires in the circumstances, not to do what the Prime Minister wants in a way that emasculates the court. So I was saddened, as were many people in the United States and in Canada, I think, to see the political tone of the hearing and how heated it became and how partisan it became. Mm-hmm. And then the other thing is, assuming after all that partisan rancor, this person has to get up on the bench and sit there with 8 other people and be seen as impartial. Well, a little bit of a problem at public perception. Now, maybe not in reality. Maybe the judges don't always do what their political mentors want, and maybe in reality, that person will become a good judge, but political perception is what I worry about. Mm-hmm. So, yeah, it's, I hope, Chief Justice Roberts wrote a rejoinder when President Trump talked about Obama judges and Trump judges. He said, we haven't got Obama judges and Trump judges. And I think he's absolutely right.
Mm-hmm. When you retired, there was some expectation and hope that an Indigenous judge might be appointed to the court, and it was such an extraordinary thing when you became the first woman Chief Justice, and I don't want to reduce you to your gender. However, I do want to ask, does diversity and representation matter on the Supreme Court? Is it important that the court looks like Canada and the people on the court come from different backgrounds that reflect Canada?
It is, and we already acknowledge that. We take people from different parts of Canada. We make sure that we have representation, at least from coast to coast. And we have now 4 women of 9 on the Supreme Court of Canada. Really important reasons, and we should have more racial diversity. I really look forward to the time when we will have an Indigenous judge on the Supreme Court of Canada. I think it's probably coming very soon, but the reality of our system is that you have to be a fairly senior lawyer to achieve that, and the reality of our society is that until recently, Indigenous people have not been going to law school in large numbers and that's changing, that's really changing fast. And so we're going to see a lot of change in the near future. But diversity is important, A, because it brings different perspectives, and I've seen this as a woman many times, and because the public, it helps ensure public confidence in the court. The court isn't some elitist institution of white males in pinstripe trousers. You know, it's someone like it's us. It's all of us, and that's, I think, important for us to remember. Now, I'm not in the appointing business. That's the other branch of government, so I won't comment on that.
I have a couple more questions before I open it up. On Indigenous issues, this has also become a very important area for you.
Yes.
And I'll quote you again from a speech you gave in 2015 when you said that Canada attempted to commit cultural genocide against Indigenous people. And genocide is a crime under international law, and I'm certain that you were very deliberate in the choice of language you used. Apparently you were the highest ranking Canadian at that time to ever use the term genocide. Why did you want to speak out at that time? Why was it important?
Well, it's important to have I wasn't making a judgment on a crime. That was clear, I think, from the context of the speech. I wouldn't do that out of court. What I did say was cultural genocide in this sense, and that is also a recognized term, not a crime, I don't think. I could be wrong, but it might be some places, but it's becoming to be recognized. The idea that you don't set out to destroy people physically, to kill them, murder them, or whatever, which is the idea behind genocide, but the idea that you undermine their culture so that that culture dies. The people aren't dying, but the culture is dying. And we did a lot of things like that. It's on the historic record. We banned potlatches in British Columbia, which was the main sort of social mechanism for Indigenous people. It was their cultural center. We said, don't do it anymore. And we sent the police in when they did. We banned the Sundance on the prairies. We took kids away from their homes and sent them to residential schools for years. We did these things. There's no argument about it. And we didn't allow them to speak their language in those schools. We didn't allow them to talk about their culture in those schools. We did these things, and whether it was intentional or not, I think a lot of it was well-meaning, very well-meaning. But the problem is that, and I think it's something that needs to be recognized, that from the Indigenous perspective, we tried to take their culture away. We tried to change their identity. And the whole policy of assimilation in the early years of the country and that kind of thing. And people did that because they thought it was the right thing to do. But now we need to reflect and ask ourselves, was it the right thing to do? And I think the answer is, most people are saying now, no. And before you can move forward, you have to acknowledge your past. So, you know, that was why I thought it was important to speak up. It did get me in a lot of trouble.
Yeah. Finally, you were involved in some, very monumental rulings that really defined our rights as Canadians and what they meant. I'm wondering, of all the decisions that you were a part of, is there one or two in particular that feel the most significant to you, the ones that felt either most meaningful or you felt that they were significant in, changing our society or defining our nation and our values?
I think the secession reference, which was a very important decision in defining Canada as a nation, and how we would handle with how we should approach this whole the threat at that time of Quebec separation, and defined us as a democratic nation that would sit down and talk, that before it would fight, that would listen, and so on. And I think apart from that, it's a very important legal case that has been probably more cited and looked at in legal academia and court judgments around the world than in any of our other decisions. And I think it was a decision by the court, all of us speaking, but I think I am very proud of that achievement. And the proof of the pudding was that both sides professed that they had won. So we had peace where there had been strife. But other important areas have been in the areas, in cases that involve vulnerable people, be they Indigenous people, people who are at a disadvantage. I've always found myself drawn to these kinds of problems, and whether it's Indigenous people, whether it's people living in a world of gender stereotypes where they feel they can't express themselves and be themselves, whether it's the right to assistance at the end of your life when you want to die, whether it's keeping insight open so that lives can be saved, and in some cases we hope turned around with the appalling specter we have, and it is truly appalling in our nation, of addiction and fentanyl and all of that. These are the kind of issues that really spoke to my heart, and of which I found myself drawn in, and I hope that I made some small contribution in some of those areas.
Thank you.